Welcome to today's LawWorks Legal Primer series webinar on key developments in Singapore's labor law landscape. This webinar is organized by Pro Bono SG in collaboration with NTUC. My name is Regana. I will be your moderator for this webinar. Before we begin, here are some housekeeping matters to take note of. Today, we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any point during the webinar and also vote for the questions by others you would like to be answered. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Then key in our event passcode, which is LawWorks 03, LAWWORKS 03, as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. If you are viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Finally, and most importantly, please note that today's discussion is not intended to substitute any form of professional legal service. And if you require specific legal advice, please consult a lawyer. And now I would like to start by welcoming our distinguished speakers for today's webinar, Kala Anandarajah and Patrick Tay. Allow me to first introduce to you Kala Anandarajah. Kala heads the competition and antitrust and trade practices at Rajah Tann Singapore and leads the corporate governance practice. Kala has written widely on corporate governance, including books on the subject. She currently sits on the BCA board and is a member of the external review panel for SAF safety. Next, joining us on the panel, a very familiar face, is Mr. Patrick Tay. Patrick is the Assistant Secretary General of NTUC and the Director of NTUC's Legal Services and Strategy Division. He is also a Member of Parliament representing Pioneer SMC since 2020. Thank you both for joining us today. Very interesting topic. So this year, we have been witnessing some noteworthy shifts. Our government has accepted recommendations from tripartite working groups that will pave the way for many in 2024. These include changes in the platform worker regulations, workplace fairness legislation, and even substantial increase in paternity leave, quite exciting there. So whether you're a delivery auntie or uncle, a cab driver, an employer striving to create a more inclusive and productive workplace, or a new father, this webinar has something valuable for you. So to kick us off, I would like to invite Kala to walk us through the intricacies of these shifts and transformations and their implications for both employees and employers. So Kala, who will provide us with more insights and light. So Kala, after you.
Thank you very much, Regana, and a very good evening to everyone. I just want to sort of say one thing. I'm no longer on the board of BCA. I've hit my term, so I've stepped down. Apologies. I should have let Regana know that. Now, in terms of employment law, it is something that I've done for now more than 25 years. So I've seen the entire employment landscape change from being very sort of pro-employer to now where it's hit a balance and sort of moved towards taking care of the employees in a big way. And so changes occur over the years, with this year's budget announcing quite a few changes. Now, what I'm going to start off with is 3 or 4 points that have come out from the budget that affect you individually as employees. Some of the good things that come out of it. And as I do this discussion, right, I will highlight pointers that you can sort of be alert to, take advantage of, but also give you sometimes the perspective from the employer's side of it as well. Because at the end of the day, it's finding that balance. So with that, let me start off with the first slide here on CPF rates. The good news is, likely in keeping with inflation and so on, CPF contribution amounts will increase. So currently our CPF ceiling has been set at $6,000. It used to be lower before, believe me. It's come up over the years, and the intention now is within the next 3 years to bring it up to $8,000. That is definitely good news for you, because it is not just the employee contribution, it is the employer contribution that you need to be looking at as well. In terms of the time frame, I've set it out there on the slide. It starts this year, not next year. So with effect from 1st September to the end of the year, the limit goes up to 6,300, and then subsequently it increases every year. Now, apart from all of us as employees in a company, right, platform workers perhaps are seeing the biggest gain. Platform workers, you have the employees, individuals who work as employees with platform operators. You also have the independent individuals who do not really sign an employment contract. To sort of bring it and make it fair, to provide for the platform workers in a form of as a form of protection, CPF will now also be paid for them. I think that's definitely something to be welcomed. This will take effect from 2024. The next thing in terms of CPF contributions is for senior workers. This will also be gradually increased, the quantum amount, starting with effect from next year. If I move on to my next point, talking about parental leave. Now, one of the best things announced in Budget 23 was an increase in parental leave for working couples. This makes me wish I was 30 again. So for paternity, for the fathers amongst you, historically you had no paternity leave. And then it gradually increased with childcare leave. And then the concept of paternity leave came about and eventually landed at 2 weeks. This will now be increased to 1 month with effect from 1st January 2024. Now, extremely good news for all of us as employees. But from the employer's side, it means that you need to be planning properly in advance because you do not want to experience sort of resource constraint as well. And hey, women, it's not just us going on maternity anymore. So kind of fairness there as well. Second key change in relation to sort of trying to improve the family environment, unpaid infant care leave for the child's first 2 years will be increased from 6 days to 12 days. So that is, again, something to be welcomed because previously not something that's easy to take. Now, if I move on to the next slide, talking about the tripartite standards in Singapore. Now, all of us know that in Singapore, for the longest time, we always work on the basis of tripartite alliance, which is government, employer, and employee. And various aspects over the years have sort of brought the three together to ensure there's mutual benefits for all parties, for employees that they're not taken advantage of, for employers also to kind of find the right balance as such. Now, before I go into like stuff that's been pre-existing, new things that are coming out. So flexi work arrangement. We've been talking about this for many years, I've been talking about it since the 90s with clients, but there was no such thing. It's very hard to sort of push for it. So it's fantastic to see that there will be a tripartite standard on flexi work arrangements introduced. Patrick, who comes from NTUC, of course, will talk a lot more about this in later. So right now it's voluntary, but it will be implemented as part of the guidelines. And then you might say, hey, but guidelines not compulsory, but it's still voluntary. The reality is, as an employment lawyer, I know that if you do not comply with the guidelines, it could make things difficult for you as an employer. So employees, you do have benefits. So you might not get thrown into jail, employers, you might not have to pay a fine, but there are various other administrative methods through which Ministry of Manpower, as well as TAFEP, the Tripartite Alliance for Fair Employment Practices, will deal with the issues. And trust me, the unions are not letting you off on this front. Important point I do want to highlight, because I look at it from both sides, employer and employee. We want flexi work arrangements. And yet, I think as employees, all of us also need to understand the employer's perspective. Because if we are all off on flexi work arrangements, then how to do business, how to grow the company, how to get more bonuses, right? So it's a balancing act, but all said and done, it's a good thing, okay? Now, just in terms of timelines, note that there will be also, sorry, not timelines, another key element to be talked about is the workplace fairness legislation. We know that there's been the TAFEP guidelines on fair employment practices for a long time now. It's been about 11, 12 years now. This will now be made into legislation. You would have seen various draft papers on it. Parliament has discussed it at length as well. The legislation itself will be introduced in the second half of next year. The intention of the workplace fairness legislation is to complement, not replace, all of the existing tripartite guidelines. So watch out for that. It will feed into the bits on discrimination that I will talk about in a little bit. If I move on to the next point about progressive wage model, you know, one thing, and this is a personal view, that we get asked all the time when we advise multinationals in particular, do you have minimum wage in Singapore? And then we say, no, we don't have minimum wage. But reality is, and as I repeat, this is my view, reality is we do have minimum wages in the form of a progressive wage model, which gives employees assurance that they're going to get a certain minimum. But it also gives the employer the flexibility to pay above that and to work around that number as such. So the good thing is, before that, over the years, we started with one industry. We gradually extended that to the cleaning industry, to security personnel, and this is being broadened even further. Come next year, or rather with effect from this year, the progressive wage models have been extended to those working in the food services industry as well. So anyone, you know, processing food, central kitchens, restaurants, and so on, you would have a minimum amount that will be paid to you. Looking at it from an occupational progressive wages, with effect from September, occupational progressive wages will become a requirement for drivers, for administrators who are Singapore citizens, who are permanent residents. So there's a bit of a differential there. Singapore citizens were being taken care of as well, just to give you that assurance. In relation to each one of these, right, there were transitional periods implemented. So talking about food services first, there was a transitional period from 1st March to 31st August, just to get employers to also understand how the process was going to work. But all of this is now ended, so it's there. You have it, all right? So that's good news, right? Moving along to my next point, compass. This is in relation to employment of foreign manpower. As Singaporeans, many of us have always felt that sometimes there are way too many foreigners coming into the country, taking away our jobs. The reality is we are a small population. We do need foreigners to come in. So how do we find that balance? How do we ensure that every Singaporean who is eligible, who is well suited for a particular job, gets that job, not a foreigner instead, but yet ensure we have enough hands and legs in the office to be able to get the job done? So bringing in the foreigners. There have been various systems put in place. It's worked well to a large extent. But to sort of give it a little bit more objectivity in terms of how we hire foreigners, this new system of compass or complementary assessment framework will be introduced. For this particular framework, we're going to be looking at various criteria. So you look at, depending on the level of the individuals, right? For this one, we're looking at individuals earning $5,000 and above, up to a limit of $10,500. Within that group of individuals, it's a question of how then do I decide whether I can hire the foreigner or not? And there are a whole range of different criteria that have been put together. There are foundational criteria, there are bonus criteria put together as well. In today's session, I cannot go into the details of it. Everyone will get confused. It's too granular, but it was important to highlight this point. Now, before I leave this slide, I want to stress that if we are looking at super senior individuals earning more than $20,000 a month, they are exempted from this requirement. So this is really to protect the bread and butter of the mid-level individuals, those earning above 5,000 up to the limit of 10,500 as starters. Okay. All of our other discrimination laws do not go away. The concept of Singaporean core does not go away. It kind of all works hand in hand. This is intended to give an objective criteria, as I highlighted. Now, just moving along to the next slide, still on Compass. This is the one where I said that it's too complex to be able to discuss each and every point. We put this up more to sort of give you an idea of what the foundational criteria might look like. So you're looking at salary, looking at the different percentile of individuals, and then you're going to go into the foundational criteria, which will look at nationality of the PMATs. It would look at how many local employees do I have, what's the support level looking like, and so on. This is not complete. This is just a sample. Finally, I also look at the skills level. And if I am working in an industry or an area where there's a shortage of personnel, then I might need to bring in more foreigners, for example. So that's something that we need to be thinking about. As I look at that, nationality always plays a part. It is not ignored. Okay. So big picture, happy to take questions on it, or Patrick will be happy to answer all of the questions. He's the expert on this one. Now I move on very quickly to harassment. What is workplace harassment? I want to very quickly touch on this topic because we see a lot of newspaper articles on this issue, where employees could be alleging that a superior has harassed them. It could be two very senior people alleging that one has harassed the other, and so on. It is a serious issue, and it's something that I just want to sort of give you a flavor on. It is not something that we can discuss in 2 or 3 minutes like I'm doing right now and be complete, but at least you start thinking about some of the issues. So going on to my next slide, what really is workplace harassment? Very colorful slide. I tried to break it up into 4 key categories. First one, the orange box. What is it? It's anything that comprises of something threatening, abusive, insulting words. If I call you, you stupid lah, you're always doing things wrong, that could potentially be harassment. I don't think any employer does that anymore, but if there's something like that that's happening, which, in our minds, we might think that, hey, I'm joking or I'm not that serious, but that could be harassment because you need to be thinking about the recipient. How does he feel? Does he get scared? So looking at it from that angle, right? So ultimately do I get distressed by what is being said to me? Who can be harassed and who is the harasser? Essentially, it can be direct. It can be, so I can come here and scold you like I did just now. It can be, if I come and sort of put my hands on your shoulders from behind or whatever, whether girl on girl, girl on boy, boy on girl, man on female, whatever, it doesn't matter. There is always the risk that could amount to harassment as well. Our world has changed a little bit. move backwards. Meaning that don't be so ready to go and put your arm around someone. I was going to do it on Regana, and I was like, better not. For example, it is something that we're very used to. So unless you're super close to the person, don't. In the workplace, maintain decorum. And it could be, like I said, superior, junior, two juniors, two superiors, any different levels. So co-workers in any which way, as well as third parties who come to the premise as well. So contractors coming in, interns coming in, be very careful in terms of how you say things, what you say. Where it can be physical, like I said, in the office environment, but it can be through email. It can be through WhatsApp. A lot of cases are through WhatsApp. It can be through social media. I go on Facebook, I go on Insta, and I say mean things about you. That's harassment as well, all right? And how? It's the language, it's the cyberbullying, which is social media. It could be sexual. I can come and say, wow, you look damn beautiful today. It's how I say it. It's not just the words, it's how I say it could present a problem. Okay, so please, ladies, gentlemen, take it very seriously. The list is non-exhaustive, and there could be a lot more. Where is the law contained? I didn't put a slide on that. Just very quickly, we do have two pieces of legislation. One is the Protection Against Harassment Act. That one doesn't have to be workplace. That one is anyone in the public. And there are many cases on it. If you go in Google, you'll find it. And then it's the workplace, it's the tripartite guidelines on workplace harassment. So that will apply to the workplace environment. As I talk about all this, right, one of the key things employers need to take note of is making sure you have proper policies put in place in the company, making sure that everyone's properly educated about it as well. Okay. I move on to my next slide. What is workplace harassment? And I give you 4 examples there. Now, I'm not going to go through everyone in detail. You see 2 boxes in green, 2 boxes in sort of pinkish red. The ones in green were cases where there were complaints made and it went to court. But eventually the court said, no harassment. So the first one, the first case, Terence Fernandez, very quickly, he was a superior. And essentially one of the workers, there was a complaint against one of his subordinates. So he went to talk to her and he was like, hey, why do you behave this way? And he wrote an email to her. His email was a little bit fierce as such. Now, essentially, the employee felt that, wow, why my boss so fierce? And she went to raise her. Sorry, she didn't. So the person who wrote the email was basically told that, hey, you cannot be so harsh. You cannot be, in communicating a point, you need to be more sort of kinder and so on. And he felt that, hey, but I'm trying to do my job. I'm not being harsh. I didn't scream or shout or whatever. I said it in very firm language. So he brought the case to court to say, I should not have been terminated. He was terminated. So he said, I should not have been terminated. And the court actually agreed with him. So, it's, whilst I say you cannot be too fierce, there needs to be that line drawn. And to all of the employees listening in, just be alert that if you want to complain, be sure it's because the superior, your co-worker, is really being nasty to you, and not that he's trying to do his job and being firm. So I can say the same thing in a nice way, or I can say it in a nasty way, right? So that's the case of Terence, and basically the court said that he was not harassing the employee. He was just dealing with a problem. A customer had complained. He was trying to make sure that it was properly dealt with and the employee understands. Okay, so very clear, right? The next case essentially was about the boss resigned, but apparently he criticized the complainant's work performance and manipulated her into thinking that everything, that's a claim, into saying that everything was her fault. But is this really workplace harassment, or is this feedback that's being provided? So you got to find that balance as well. The next two cases, without going into details, just reading the headline, very clear. This ex-teacher who sent an anonymous message, so he was working in a school, he left, he sends anonymous message back to the principal and another school teacher to kind of say that they were handling things wrongly in the school. They caused a problem which resulted in someone committing suicide. The cases were unrelated, but that's what he kept doing, and he kept saying very nasty things. The court held that that was clearly harassment. That's workplace harassment, but that was also under the POHA, which is why he got jailed. Under the POHA, Protection Against Harassment Act, you can go to jail. The last case, without going into details again, it's about sexual harassment. Apparently, a man groped his female colleague. More importantly, I want to highlight the language he used. He said things like, "Wow, swear if I single, we'll be flirting hard." And then he laughed. If you say that alone, I find it very hard to be harassment. Swear if I single, we'll be flirting hard to be harassment. But then you add the other things. Oh, he really got a nice bump. It's getting a bit too personal already. That starts moving it into harassment. So please, ladies, gentlemen, watch how you say things, what you say as well. If I move on to my last point on discrimination, very quickly on discrimination, there's a lot that can be said about this as well. Now, I am personally glad that the TAFEP guidelines on fair employment practices were introduced, like I said, slightly over a decade ago. Under these guidelines, the intention is to make sure not just Singaporeans are protected, but there's no discrimination on the basis of language, on the basis of race, importantly on the basis of gender, and so on, so that every one of us has a fair chance. And that whole idea about discrimination starts from the point in time that advertisement goes out. Many of you will know that there is a job bank, which is now known as My Careers Future, MCF for short. That particular website requires an advertisement to have been made first to justify primarily why am I hiring a foreigner, if there were Singaporean applicants as well. Very good. Moving along, some of the questions now you cannot ask. You cannot ask things like, are you married? You cannot ask, can you give me a photo? You cannot ask, what's your IC number? Why? IC number, no big deal, right? Actually, big deal, because looking at the IC number, you can tell how old is the person. And it could be ageism. It could be, I only want to hire older, I don't want to hire younger. Or it could be, I only want to hire younger, I don't want to hire older. Possible discrimination. If you look at a photo, it's like, very ugly, I don't want. Possible, right? Or you look at the photo, you will know straight away the race, the gender, and so on. So these are things that you don't ask. You cannot ask about whether you're married, because if you ask a female, it's like, why you think I'm married, I cannot work, is it? You think I'm going to be pregnant and on maternity all the time, is it? Those are the kind of issues that come up. So don't ask these questions. And it's not just at a hiring time, it is throughout. So promotions, how you issue bonuses, and even when you're doing a termination or redundancy exercise, all of these have to be considered. Now, I've said these points very quickly, highlighting really top-level things. I hope I'm getting you thinking and that you will have lots of questions. I talk like a typical Singaporean, right? Very fast, like a bullet train. So I hope you have been able to follow me. Happy to take questions. With that, I'm handing it back to Regana. Thank you very much, everyone.
Thank you. That was not too fast. I was writing and scribbling, but we do have some questions. So Patrick, before we go off to you, let me just grab a couple of questions here. I think it's more of curiosity, I think, from one of our audiences. What is the most common type of workplace harassment complaints that you have seen that companies have faced, both from the private practice and the MOM perspective? Like, is there a specific kind of harassment? I mean, yeah.
Okay, if I pick this one up first, the most common form of harassment that I've seen tends to be, unfortunately, sexual harassment. And things that, I've worked for a little bit longer, things that I would have thought were acceptable 20 years ago are no way acceptable now. So sexual harassment comes up all the time. They're not always spot on, they're not always accurate, but employers, if you do get something like this, an employee is complaining, take it seriously, go through a process of investigation and manage it. The second most common is where employers or supervisors are being abusive, for example, unfair. So that's what I see as well. But over to Patrick.
Yeah, maybe I just add on the number of cases. I think this, in fact, earlier this year is the very first time the Ministry of Law during the Committee of Supply this year have released figures on the number of what kinds of harassments that the POHA court receives. Or because as Kala mentioned earlier, we now have the Prevention from Harassment Act, quite a number of years already. And we even set up a POHA court just to look at POHA claims. So they have not given too much granularity, but workplace harassment actually is one big chunk that comes up over and above your other kind of harassments, whether in a public place, etc., or in private settings. So yes, workplace harassments is something to take note of. And like what Kala mentioned, increasingly we greater societal changes and acceptance and expectations, and well, in a way, social fabric has changed a bit, and therefore you see what is it's not tantamount to harassment a while back, a decade or two back, now seems to be maybe real tantamount to harassment. So so just take note of all these, and some of these cases, POHA cases, have also been published as shared, and I think it's good that the State Courts is watching this space as well. So we'll hear more updates, on a regular basis, the kind of claims, and to see how the magnitude of the problem is. But say all you want, yes, there are still workplace harassment claims still ongoing.
Thank you very much. Just one more question. I think let's clarify for our audience. If a company restricts a female staff on dressing, meaning that it only allows their female staff to wear skirts or long pants, specific tops, no long sleeves, and obviously male staff do not have this restriction, is it constituted as sexual harassment?
Very difficult one. I wanna say that I need a little bit more facts. What is the industry you're working in, for example, and why? Now, even as I say that, right, I think unless it's an industry that calls for uniforms to be worn, like some of the uniformed professions that we have, I find it very difficult in today's day and age that you would tell a lady that, sorry, you can't wear pants, you must only wear skirts. Or, sorry, you can't wear long sleeves, you must only wear, I'm adding to this, sleeveless. I would think that that's a real problem. It may not be harassment yet, but that could potentially be a real problem. It could be discrimination even.
Patrick, anything to add?
No, Kala said it. We probably need to hear more of the facts and the circumstances surrounding why that occurred.
Thank you. So now we're gonna turn to Patrick. You give Kala a little bit of a rest.
Yeah, that's right.
Before we throw more questions. But Patrick, workplace fairness legislation has been discussion for so long, over 10 years. And it's really, really good news that, the government has finally accepted all 22 recommendations from the committee. I know that you have been in the thick of this and long night meetings. So can you share with us what you are hearing and you're seeing on the ground about these recommendations and the possible effect in the employment landscape?
Thanks, Regana, for that question, and also give me an opportunity to add this, and at the same time also give Kala a break. And Kala actually gave quite a good overview of some of the key pieces or major changes. Of course, the workplace fairness piece is one important piece. I thought, firstly, I would declare my interest because I'm the one who lobbied for this and quite a number of years back. At the same time, also, partly because I lobbied for it, I was dragged in to become part of the work group or committee to look into this deck of recommendations, which were fleshed out just a couple of months back. And I thought to trace a bit of the genesis of this. As Kala mentioned, we set up the Tripartite Alliance for Fair Employment Practices, TAFEP for short, quite a while back, almost more than a decade. And over and above that, there's also the Tripartite Guidelines on Fair Employment Practices, TGFEP for short, Tripartite Guidelines for Fair Employment Practices. So I think we must take cognizance of these two, because these two, the TAFEP and the TGFEP, will continue to exist post the workplace fairness piece of legislation that will come up according to the Ministry of Manpower in Parliament, as well as when the recommendations will roll out second half of next year. So I'm looking forward to that. And the Labour movement is also looking forward to that. And if you recall, the Prime Minister in the National Day Rally 2021, August 2021, did share that we are going to look at this, having this piece of legislation. And our Tripartite Committee was subsequently formed. And yes, Regana, you're right. We met on many occasions. It's quite a high-powered committee, and we consulted far and wide and examined many jurisdictions, different practices across the globe, from Asia to Europe to America, and looking at the various iterations of anti-discrimination legislation. And here we are. I won't go into the exact thought process of the journey, but essentially 22 recommendations, all well thought through, because I think what we have done, or we have tried to achieve, is to try to make something that's firstly that's suited for the local context. I think that's one very, very important. Second is we took a lot of reference to our TGFEP, Tripartite Guidelines on Fair Employment Practices, so that we keep the key guidelines and principles intact. And then we develop and augment from there. And thirdly, the good news is the number of, discrimination cases, it may look quite big, but we have, in Parliament, it's been shared by Ministry of Manpower, we have about 315 discrimination cases annually for the last 5 years. That's what TAFEP has investigated on. So it's 315 cases for the last 5 years. So that's the magnitude of the so-called problem. Depending on how you look at it, it may be a big problem, it may be a small problem. But I must say, anecdotally, I think in Singapore, the bulk of employers are in compliance with many of the rules and regulations, including tripartite guidelines, and don't want to run foul of the authorities and whatever administrative measures that might be imposed. So I'm glad to share that in general, employers are in compliance. However, there are one or two perhaps more recalcitrant or more egregious cases. So that's where this piece of legislation is targeted at. Because if you look at the 315 cases annually I shared about the last 5 years, the bulk of it, two kinds of discrimination. Firstly, age. Second, nationality. So these were the two most predominant kind of discriminations that occurred out of this 315. Yeah. So take note. Why do I say we take note? Because we want to, address and nip the problem at the bud. So I think these two are two of the characteristics. There's a list of characteristics splashed out in recommendations and will be entrenched in the workplace fairness piece of legislation. So areas like age, nationality, in the report it says sex or gender. I think that includes pregnant women, and over and above that, even persons with caregiving arrangements. So that's something new. If you are discriminated because you have caregiving arrangements, then in the new piece of legislation, that's going to be addressed, including, of course, in our multicultural, multiracial, multi-religious society, race, religion, and finally, disability. Disability, it has been articulated during the fleshing out of the recommendations that it will now include mental disability. So I would say I am quite happy and elated that we have managed to make some breakthroughs this round. It's going beyond the traditional TGFEP to cover, as I said earlier, because many of us now face caregiving arrangements and challenges with that, with elderly parents, our parents living longer, grandparents living longer, and with still young children. So we are really, really sandwiched in that sense. So therefore, caregiving arrangements is one big concern recently, where we had our Every Worker Matters conversation and rolling out our Workers' Compact. So I think this part will be addressed in the workplace fairness piece of legislation. Then the other question you ask is then, how do we are going to go about making a complaint through this workplace fairness legislation? So more details will be out next year when the piece of legislation is out. But essentially, it will follow pretty much the route of current employment disputes and claims through TADM, Tripartite Alliance for Disputes Management, and perhaps even through the Employment Claims Tribunal. That could be one route or route of approach. And take note, what's also unique about this workplace piece of legislation, workplace fairness piece of legislation, is that it will include, as Kala briefly mentioned, pre-employment, when you attend a job interview or a prospective employee, including in employment, and you're discriminated in the workplace when you're in employment or when you're exiting employment. So besides termination of employment, there's also cases where you'll be discriminated when you are being retrenched. For example, a company retrenching part of it or older workers. So it's a clear cut of age discrimination if they can't justify that. So these are some of the latest measures in the workplace fairness piece of legislation that's coming up latter half of next year. And there will be penal measures, even civil measures, civil penalties, etc. So, well, look out for it. It's going to be ready. I think they are busy, in the drafters table. But like I said, more details, the exact final details should be out later next year.
Thank you very much. I have a couple of questions from our audience. So this is an interesting one. An MNC requires information sometimes for security checks, and they need to check your nationality to do background checks. Is that sufficient justification to ask such information in the application form? Your nationality, your race, your religion?
Yeah, you might just touch on this on the nationality bits. As you know, in Singapore, if you are a foreign national, there are 3 categories of passes. Firstly, the work permit. Secondly, the S pass, and finally the EP or the employment pass. So as part of the bringing in workers who are not non-Singaporeans, there are these passes. So in the process of applying for these passes, employers need to know the nationality, and they need to know the details before they can actually apply for those passes, and for yourself to fill in the forms and the necessary forms to get your relevant passes. So in my view, it will not be discrimination simply because the rules and regulations and the foreign manpower regulations require such details before entry permits are issued, before you can start work, and these are statutory requirements. That's right.
Hello?
I agree entirely with what Patrick has said, but I think the key thing to note there is you would already have hired the individual. So the question of discrimination doesn't come. So the point about asking the nationality is really more because you need to go through an administrative detail. Now, if you're doing background checks, it's a little trickier. I think in today's day and age, perhaps for background checks, and that means before actual employment, nationality may need to be looked into because we have sanctions laws, for example. So nationality, yes. But if someone says, tell me your religion, I would like, what has that got to do with anything? Because I could come from country A and have a religion B. Religion B does not have anything to do with sanctions. So again, it's knowing the specific questions and the rationale for it being asked. So religion, I think we are justified in not wanting to respond.
Thank you. So I have a question. What can the employer do to ensure that they're not collecting? So now, let's say they're putting up a job advertisement and they have these forms to fill. Any advice for the employers out there that what can they collect? What are they allowed to collect?
I think the key thing is if you look, important to look at some of the MOM resources. I think the Ministry of Manpower's website is very comprehensive. Many of the forms, even online forms, instructions, even some calculators and some tables and charts are all available there. So you can draw reference to that. Some of the forms are available. Some of the forms are even statutory and are provided in the regulation. So if those details are in the prescribed forms and you're asking for those information, I don't think you will run foul of any laws.
Thank you. So we have another question, which I think is really cute. Does the guidelines cover civil servants?
You're talking about which guidelines?
So I'm assuming the workplace legislation, I'm
The
assuming.
workplace fairness legislation, I think we have some discussions on this. So there's a likely situation where it may not cover the public sector, simply because the public sector already has what we call the government instruction manual, which is very comprehensive, quite a number of volumes of it. I recall vividly because I myself, in my first career in the civil service, has gone through examinations on the government instruction manual. So it's very comprehensive. It's even more comprehensive than the Employment Act, and therefore, in that sense, it's already covered by those provisions.
Okay. And actually, I have another question. Can an employee succeed in complying? Basically, it's asking if they had a mental issue, do they have to submit a doctor's report to the employer, or if there is no substantial way of showing medical reports? I think that's what they are trying to ask. So can the employer ask for medical reports, actually?
That's again a very good question. And I think what you need to be thinking about is, from your perspective, I have a mental health issue, but at the same time, we need to look at it from the employer's perspective. So from me as an individual, if I'm going through a difficult period of time, for a short space of time, I say, I really need a mental break. I need time out. Most employers will say, sure, take a few days and so on, or lighten your workload for a few days. I think that's fair. And usually you talk about it, and I've seen it happen. And usually you do not require a medical report. On the flip side, if you're going to have this issue continue for weeks, for a month, 2 months, 6 months, and I've seen that happen as well, it's fairness on both sides, right? Because at the end of the day, the employer also needs to ensure that business can function. So, and he needs to be sure he's being fair to the rest of the employees as well. So in that instance, in my view, the doctor's certification becomes important. And I'm going to ask a question myself. So the doctor, can it be my own personal doctor, or do I need to use the company's doctor? Here again, if it's a short-term thing, using your own doctor, I think perhaps, but we've also seen situations of sometimes that being abused. And so strong recommendation is to use one of the panel doctors. So at least for the company, it's like, if a panel doctor says, they can't sort of say, no, right, I'm not going to listen to my panel doctor. So it provides you with that balance as such. So I hope I'm answering the question that was asked.
Great. Anything to add, Patrick?
Nope.
Just one last question. What are the preparatory steps for an employer? What should an employer be looking out for to prepare when this legislation comes in full swing in 2024?
Yes.
So this is actually quite important for all our employers out there. So Patrick, want to start first?
Yes. First thing, read the 22 recommendations. That will give you not just a hint, the very strong likelihood of how the workplace, or should I say the ambit of and coverage of the upcoming workplace fairness piece of legislation. That's one. Second, familiarize yourself with the TGFEP, Tripartite Guidelines on Fair Employment Practices, because whatever that's not going to be covered by the workplace fairness piece of legislation, recourse may still be available to employees through TAFEP via the Tripartite Guidelines on Fair Employment Practices for certain, maybe perhaps characteristics that are not comprehensively covered. So that's two. Third is, there will be a series of evangelistic outreach on this upcoming piece of legislation in partnership with different work groups and different tripartite partners and stakeholders. And do jump on the bandwagon. I know the Labour movement, we are doing an upcoming primer next year on this. So feel free to join us and be part of that primer, so that you can get first-hand knowledge, and as and when more details are being fleshed out, especially the procedures as well as the likely iterations. I'm sure a lot of employers are very eager to find out. So like I said, well, as of now, while awaiting for the bill to be, crafted, is to look at the recommendations, familiarize yourself with the tripartite guidelines, and that will give you quite a good indication of how the final iteration turns out. And also for workers or employees out there who are not yet union members, be a union member, because I just wanted to add that the union and the labor movement is preparing ourselves as well, just like we did with the TADM and the Tripartite Alliance for Disputes Management, to walk that journey with workers who are our union members, to sort of handhold them and support them in that journey if and when they face discrimination according to those protected characteristics.
Thanks, Patrick. Kala.
I'm going to look at it from the employer's perspective and say, you do need to, as Patrick says, familiarize yourself with it. Update your policies. Now, many companies out there do have workplace discrimination, harassment, and all of these dealing with age, dealing with mental health. You have these policies in different locations as such, how to handle maternity. I mentioned that because that feeds into discrimination as well, and so on. But what you want to do is holistically look at all of these and see that they meet the requirements of the 22 recommendations. So reviewing where you are, updating those are very important. But even more important than that is ensuring that your employees understand, giving them an awareness session of some sort so they know what the laws are like, what their rights are, and the assurance that you as the employer take these things very seriously and you want to work in partnership as a team. Now, I keep saying employer, employee. At the employer level, it has got to be a top-down approach. But that doesn't mean that you ignore the human resource personnel. In many of the organizations, the HR personnel are super experts, and many of the tasks are delegated to them. So HR individuals, if you're listening in, if you think you do not have sufficient help or resources and so on, go speak to the C-suite, the CEO, or whoever it may be, because this is an important area. It is part of managing your talent as a whole. Take it seriously. Make sure that awareness training is there. Make sure the plans are put in place. Make sure your policies are updated.
Yeah, it's good to have the conversations now.
Yeah,
Yes.
that's right.
Yeah.
Yeah, and especially for those who are in unionized companies, not to worry. We'll be coming to you to work with you closely. In fact, most of the collective agreements actually have already grievance procedures and various procedures encapsulated or entrenched in the collective agreement. So you have a bit less worry as compared to those who are in a non-unionized environment and do not have collective agreements.
Thank you. So let's look at our platform workers. Very exciting because I think this has been in discussion for very, very long. Just a very quick definition for our audience. A platform worker is a contract for service worker who contracts with platform operators, for example, food delivery, private car services. In other words, our delivery men and women, cab drivers or ride-hailing drivers in short, they are really set to benefit at the upcoming platform workers legislation. And Patrick, please share with us.
Yes.
What are the benefits?
Exciting space.
Yes.
I think in the last many years, we have been also lobbying on this front, especially with digital transformation and platform work being so prevalent. There's really a pressing need or imperative to have a greater protection of these workers. I think not just in Singapore, when I interact with trade unions and tripartite partners across the globe, in Asia, in Europe, US, everyone's worried. That's why you see a few high-profile cases, court cases in the UK, and even in France, even in the US, on private hire vehicle drivers, Uber, and many of these cases. So in a way, the working committee, advisory committee, or the working committee has been also working very hard the last 1-2 years, looking at the proposed way forward to address some of the pain points or challenges faced by platform workers. I repeat again, it's platform workers. So you will cover workers, as Regana shared, food delivery, as well as the other big category, it's private hire vehicle drivers. Your Grab, Tada, Gojek, that's for Singapore. And these two groups. So what the labor movement has done in the last couple of years, we have, as you know, it's a contract for service or independent contractor arrangements, and there's no employment relationship, unfortunately. So traditional employment statutory laws don't cover them or don't give them special rights or benefits or privileges or additional protection. And so, like any freelancer or self-employed, you are left on your own devices. So therefore, we actually formed two associations. Firstly, the National Private Hire Vehicle Association, because they can't be a part of a trade union because they are not employees or there's no employment relationship. So we have gotten the way around by forming associations. So we have the MPHVA, Private Hire Vehicle Association. We brought together all the different private hire vehicle drivers in Singapore so that we can collegiately as a community and as a big group look at the impact and be the voice for this group of workers. The other one is a national, we call it NCDA, and we call it delivery champions. We call them our delivery champions association because it includes all sorts of deliveries, especially food. And they are very vulnerable because either they're on an e-bike or they're on a bike on various mobility devices. So it's particularly challenging. I mean, I personally met residents who come to see me facing issues such as insurance claims.
Yeah.
I remember one of the food delivery riders got hit by another vehicle while he was negotiating a ban. And lo and behold, yes, the driver has some insurance coverage, but he himself did not buy insurance for himself, and it's not a work injury claim because it's not covered by WICA. So that's one big problem. Another food delivery as well. Negotiating a ban, scratched a luxury vehicle, got a big bill. Obviously, if you ride an e-bike, you won't have bought third-party insurance and all the full suite of insurance. And so he was slapped with a bill of just for a scratch on the side of a bonnet, $5,000. And came to see me and say, he was at, really at all fours and wondering how to overcome this. And of course, we had to advise him, maybe try to negotiate for some installment payment. Maybe it's an obligation. You can't avoid that. So these are some of the examples of challenges faced. So as part of the whole development, we have consulted far and wide, the work group as well as the labor movement. So for platform workers, there are a few pressing challenges. Firstly, payment and non-payment. Traditionally, that's always a freelancer issue. Non-payment, shortage of payment, late payments are the usual. But increasingly, if you look at our platform workers, work injury, as I shared earlier, and insurance. The other one we are particularly worried, that's why Kala mentioned about the CPF changes that will help them a bit, is retirement adequacy. Because unlike a traditional employment relationship where there's statutory CPF contributions on both the employer and employer, it's not so for freelance workers except for a particular amount to top up to pay for their MediSave premiums. So that's basically it. Retirement adequacy, work injury, and of course payment and non-payment. But over and above that, why we have band them together because we are also particularly worried about the algorithms on assigning food delivery. As you know, they have 1 star, 2 star, 3 star, 4 star, 5 stars, and sometimes even for private hire vehicle drivers, with search pricing and a lot of algorithms behind the dashboard that they are not privy to those workers. So there's a big worry on whether they'll be so-called affected or prejudiced against in the course of work. So these are things that we, as an association and as a labor movement, we are concerned about. So what's the good news? The good news is the recommendations have been fleshed out, and the Ministry of Manpower has come up publicly to say that they will look at these few pressing issues. Of course, you heard about retirement adequacy through the CPF contributions. Work injury, I think this is one thing that I think will likely have some iteration. And of course, more importantly, looking at union representation of platform workers. This is going to be a slightly iffy thing because traditionally, even not just in Singapore, when I interact with trade unions around the world, they are finding it a challenge to represent freelancers because technically they're not in an employment relationship.
Yeah.
How do we collectively bargain? How do we represent them? So here we are. Ministry of Manpower has publicly announced that we'll find some way to ensure union representation of platform workers. So we are in the midst of on the drawing block trying to find the best way to assist them or walk the journey with them, particularly our union members who are platform workers, to see how we can better represent them. So moving ahead, like the UK, if you read a case regarding a private hire vehicle drivers, well, the category of workers, whether they're so probably some form of hybrid kind of employment relationship where it's not just a pure employee, a pure independent contractor, but somewhere in between. So likely that's some of the discussions that we are undergoing, and but the details are not out. Again, you'll be fleshed out come next year.
Do we have a kind of a timeline towards roughly? I think someone did ask.
Oh yes,
guidelines and timelines.
Yeah, I hope it should be ready by next year. So that's it's really work in progress because we are going to be, in fact, many countries and jurisdictions are looking at us. I've already received quite a lot of queries and questions from our trade union, labor movement partners across the globe, saying, what's the development in this space? What are you all trying to do? What's the end result? What's the end shape or pattern of this whole dispute resolution mechanism and representation mechanism? So, but we are really, trust me, we are really in the drawing block trying to see how best to, let it be a eclectic mix of the best to provide the rights and benefits or the privileges to platform workers who may be vulnerable.
Thank you. Kala, how about the platform operators? What should they be looking out for?
I think the key thing for platform operators is you're now entering a new world as such. So oftentimes you have a group which are employees, and then you have the group which are independent contractors, so to say, so not directly employees. The changing environment is something we cannot avoid. It's necessary. It's again the do your right thing kind of thing, right? So we want to take care of these individuals. What platform operators therefore will need to do is be alert to these issues. If we're looking at workplace injury, for example, it's thinking about potential insurance elements. It's thinking about the service agreements that you enter into with them, what kind of terms and conditions need to go into that. And just that's just highlighting really, in a sense, the basics. I can't say there's a way for you to work around these things. This is the new norm. So we are blurring the employee independent contractor environment as far as all of these gig workers are concerned. It's starting with platform workers. It could find its way to other areas as well. So it's a new norm. It's not going to change.
Thank you. So Patrick, currently you spoke about the two associations. How can our platform workers sign up or attend these conversations that these associations are having?
In fact, we have already started, as I alluded to earlier on, our Every Worker Matters conversation. And this renewed Workers Compact is encapsulated some of the fears, anxieties, and concerns and challenges. So it's already in the document, classified as vulnerable workers. And like I said, if you are a platform worker, please join us through the NCDA, the Re Champions Association, or the Private Hire Vehicle Association, so that we can look after your needs. I think over and above that, we have actually other freelance groups like the National Instructors and Coaches Associations, VICPA, looking at visual arts content providers, and as well as partnerships like the National Taxi Association as well. So these are associations where we have collectively together with the workers on the ground form to look after and be the voice for them, because you never know the different challenges and issues that they face. A good example would be like the visual arts VICPA. We had quite a good engagement with the photographers. We engage freelance photographers to do weddings, to do all sorts of photography. And I recall very vividly because we worked very closely then with the Professional Photographers Association of Singapore. And that's And that was the time when the PDPA came up, if you recall. And there was a big hoo-ha on, now that we PDPA, which means I need to get consent for every person attending the wedding banquet before I can take pictures. So I remember that very fateful. I actually literally organized a dialogue session. All the photographers, a few hundred of them turned up. And when the feedback was given to the Ministry of Law and of course the relevant agencies, and they responded quite quickly. So PDPC, Personal Data Protection Commission, actually came out with some directives and guidelines to say now, you don't need a consent form for everyone. Maybe you put a standee to indicate that photographs will be taken, and if you don't want your photographs to be used or collected, used, or disposed in any way, please inform the organizers. So that's one way to circumvent without them having to go to every single attendee. Just imagine it's 100 tables, to get a consent. And the other one that came up, of course, in the last couple of years from the visual arts community, as well as even the photographers as well, is the issue of copyright. That's why I'm very thankful IPOS has worked very closely, and as part of consultation and parts of advocacy, work together to better protect them, their rights and privileges, and not whatever the creative work that they generate use perversely or use very publicly. So I think we have made some inroads in that as well. So these are exact examples of how we have worked with freelance groups. So be part of us and just jump on the bandwagon.
Thank you. And correct me if I'm wrong. I read somewhere that that's proposed that platform workers be a designated new worker category.
Yes. So Kala and myself did allude to earlier. That's how the court judgment in the UK came up to say that, well, this is sort of like a different category of sorts. In that particular, we won't go into that piece of judgment, but essentially, it may well be a new category because we want to give additional protection to this particularly vulnerable group of platform workers. So yes, likely there may be a category. The question is whether there'll be a new law. I think we shall see.
Okay, I have a question actually for Patrick. Patrick, based on your experience, has there been a push for stronger union reps by employees in Singapore in general? And if so, what should the companies do to be more prepared?
Yeah, I think the key thing is union representation or unionization or being a union member is something like buying insurance. You think you don't need it, but when you get into trouble or you need the umbrella when it rains. I've seen it personally in the past 22 years in the labor movement. Handled so many retrenchment exercises from the SARS crisis to the global financial crisis, and of course, in the pandemic in the past 2-3 years. I think the key thing is we are here to watch your backs, to be behind you, to give you the extra boost and support. Well, you may think nothing will happen, but you never know. Well, with disruption, with job obsolescence, with a lot of transformation, reorganization, restructuring going on, it's good to safeguard yourselves. And we do see our union membership has gone up quite a bit. We are something like about 1.2 million now. So I think more and more people are coming on board. They realize that, and we are going to different groups, from migrant workers to freelance and self-employed workers. So they know that the collective voice is better than standing alone before an employer or before a big multinational. So I think I just want to appeal to everyone that you step forward. But over and above that, if some of you who want to be the leader among your group, or you want to step forward to be a union leader, please approach myself. And we can stay connected, and we can induct you and see how best we can work in collaboration with our tripartite partners, including your employer, to look out for your employees. So we are not in Singapore. We are uniquely Singapore. We have a very, very strong tripartite relationship. At the same time, we also believe in collaboration, not confrontation. And therefore, we will try to resolve things at the lowest level. And employers out there who are actually watching this, do approach me as well. If you decide to, form a union or unionize a company, because then you can look after your employees and work with us, and we can give you lots more support and help you resolve things at the lowest level.
Thank you. So my next question, what's in for 2024? What other updates what does the future hold besides paternity leave and unpaid childcare?
I think I just want to augment what Kala shared earlier. She's covered quite a bit of space and in many of the announcements. As you can see, the many announcements actually roll out, not just this year, not just next year, but the next couple of years, including the CPF adjustments for everyone, including the older workers. But I thought something important is the flexible work arrangements. For the longest, it's been a tripartite advisory. So there's public announcement by Ministry of Manpower. Next year, there'll be a tripartite guidelines. As you know, I like Kala when she said, although it's guidelines, please comply with it. I can attest to that because I've appeared before the Industrial Arbitration Court on many occasions. And yes, the court does give sufficient weight to tripartite guidelines and what it pronounces. So please comply with it. Yeah, and in Singapore we have in a way, usually when there's advisory, becomes guidelines, and one day it may become law. Like what we did with older workers, it started with tripartite guidelines, and then it became the Re-employment and Retirement Age Act. So likewise the TGFET now workplace planners. So I won't say it's akan datang, but essentially there will be tripartite guidelines on flexible work arrangements. But I thought something interesting came out recently. I think some employers as well feedback. Does it mean flexible arrangements means we can all work from home? So that question came up quite a bit, and I wanted to sort of like clear the air to this evening. And then I thought good to understand what is flexi work. Flexi work does not mean work from home completely. Flexi work comes in three forms. Firstly, flexi place. In some jobs, there's a possibility of flexi place, whether anywhere. It can be even outside of jurisdiction. So flexi place. So that's one. Sometimes you may not be working from home. You may be working from a co-working space, or even at a cafe, or even at a restaurant. Oh, I like that, the beach. And the other one is flexi time and flexi shift. This is not new. Staggered hours, 4-day work week, but you still keep within 44 or whatever there's the statutory hours as prescribed, or your company's own prescribed hours. So it's X number of hours, but it's how you redistribute it in the calendar month or week. So that's a flexi time and shift. And the last one is flexi load. Flexi load. So flexible arrangements will include flexi load, job sharing, and of course a lesser load. Of course, doesn't mean at the same pay. There'll be some adjustments. Maybe for the not so young workers, or maybe to adjust the load so that maybe perhaps for caregiving arrangements, etc. They may need the afternoon off, and so the load is halved. So that's important to understand that flexible arrangements includes flexi place, flexi time stroke shift, as well as flexi load. So just to clear the air, because everyone thinks flexible arrangements after the last 3 years is work from home. The answer is not. So if you ever get this question, or you ever expect, or especially employers here who are preparing, and employees as well looking at asking for flexible arrangements, these are the various arrangements. And for SME owners out there, employers out there, TAFAP is quite kindly, because there's already a tripartite advisory on flexible arrangements. It's a nice guide. It's not many pages. It gives you it's available online. I don't have the web address. Maybe we'll try to post it somewhere or send it to you. But then you just go to TAFAP's website, you just navigate it. There's a nice guide for SME owners on implementing flexible work arrangements. And they give you quite a step-by-step way to how to implement what I just shared earlier.
Thank you so much. Anything else that we should know about, or anything else?
I think it's, we have been quite comprehensive, I must say. Thanks to Kala, who has covered most of the ground in the major announcements this year.
So I'm going to ask about the paternity leave, because that's I had a conversation with my friend. And can an employer deny the additional leave?
My take is, the moment it becomes legislation, the employer cannot deny it. So it will have to be provided. With Regana's permission, I'm just going to go back to one point just now.
Please.
In relation to the various guidelines, right? I want to emphasize again, even though it is guidelines, even though there are no criminal penalties associated with it, The biggest harm or difficulty employers will face, and that's kind of the way a lot of organizations, government organizations in Singapore work, is to make it difficult for you administratively. So if you don't comply with the guidelines, you might be slapped with delays in various things that you want to get done from an employment perspective. And that has a direct impact on your work ability, work performance timing, potentially, eventually output and so profitability. Hence, I always see that as a bigger constraint from a business perspective rather than I go to jail for 10 days. I don't want you to, but I'm saying that it is a very real thing. Just to highlight that.
Thank you. I believe we have some questions actually from our audience. So let's look at some. So we have a question on, will certain categories of employees, for example, caregivers, have stronger protection under the new flexi work arrangements? Patrick.
I would say additional. There's already this set of tripartite advisory and the guidelines. So you will, so it's still in discussion. I mean, there's a work group looking at it, and you get more details next year as well. And essentially, I think, as I shared earlier, the three different kind of flexible arrangements, it should provide everyone with that option. And we are trying to go on, well, in a way, encouraging more employers to be more open. I think especially the changing demographic profile, changing demands of our society, longer life expectancy, and of course, all our various sandwich arrangements. There will be expectations from employees that when they work for a company, they want to be more engaged. When they look out for employers, they will want employers that provide flexi arrangements. In fact, as part of our Every Worker Matters conversation, I think as well as our youth task force that we had, where we consulted far and wide, many of the young people want join organizations where there's some form of flexibility, not necessarily work from home, but flexibility. And that's come up quite a bit from the so-called new entrants in the workforce of tomorrow.
Interesting. Very interesting. I do like the flexi hours too. So that's a perk. So I have a question for Kala on recruitment. And basically the question is, would a reference check on a potential candidate be deemed as discrimination? Because sometimes some employment forms need you to give an ex-boss or a colleague. Some people put friends. So, which I still don't understand why. Is that discrimination?
I would think that a reference check is not discrimination. Simply because, I mean, it's to get an objective view. And typically you would provide the prior employer or someone of some standing. In some industries, it is expected, and by the rules that guide the industry, for example, it is expected.
Patrick, anything to add?
Kala has said it all.
Okay, I have another question. In your experience, both of you actually, what are some of the administrative actions that MOM can take against an errant employer? Maybe Kala?
I think Kala is advising
Kala?
employers on this point. Well, to let her take a short breath.
Yeah, Patrick.
Essentially, work pass privileges is one of them.
Yeah.
That has always been the one that many employers, particularly those who have to hire foreign workers and foreign manpower, are particularly worried and find that even more punitive than sometimes paying fines. So that's one of the administrative measures which the Ministry of Manpower will undertake for any non-compliance, or if you are put on a blacklist of sorts, or any kind of breaches.
Kala, do you want to add anything here?
Well, Patrick has said it. I just want to allude to the fact that when I kept talking about administrative pain and potential delays, that's one of the key things that I was referencing. So.
Okay, we have another question. If I'm a victim of workplace harassment, should I go to my union or direct to TAFAP, TAFAP? Which is more effective, or should they go to the HR first processes?
Depends on the routes. or depends on your status. If you're a union member, I strongly advise you to go to your union. Yeah, so that the industrial relations officer or the trade union leader can assist you in that journey and advise you accordingly, or even help you to resolve it with your company management or HR. So that's one route of approach. If you're not a union member, which I suppose a number of you who are tuning in are not union members, yes, you can make a report to TAFEP. That's another course of action that you can go to. But if you're very, very sure that, well, in a way, you've been, you were talking about harassment, right?
Yes.
There's actually recourse to the state courts through the Prevention of Harassment Act, POHA Court. In fact, you can just check out the website, the state courts at gov.sg. They have a very nice flow chart to kind of like give you a very, very simple step-by-step guide on how to file a POHA claim. So these are some of the avenues that are existingly available.
Kala.
Hi, I'm going to add a little bit to that. So, you know, I was dealing with an employment matter yesterday, and the HR manager came into the room when we were talking, and she was like, "Here's the family Wi-Fi." And I looked at her like, "This is the workplace." I said, "Yeah, but you know, we are all a family," and that really struck a chord with me. And I highlight that because if there is a harassment issue, and I appreciate that the union sort of is also like a big family kind of thing, but generally, if there is a within the office complaint, a workplace complaint, depending on who it is, take it internally first. So if the complainant is, if the harasser is, say, your superior, not HR, then go to HR. And most enlightened organizations will have a process to deal with that. So go to HR, let's see how it can be dealt with. And if it's HR that is harassing you, then look to see who is the next right person to go to. And if necessary, go up to CEO even. They will take it seriously. So start with that. If that is not giving you the guidance or it's not giving you the help that you need, then yes, go to your union. Go talk to a lawyer friend, and so on. Before you go to POHA to use the Protection or Prevention Against Harassment Act, or go out and make a police report, just think about the consequences that come from that as well. So again, it's something you want to think very carefully about before steps are taken. But my suggestion is always what happens in the family, keep in the family first, unless you're really not getting help. So go to HR. HR is fairly enlightened. Thank you.
Thank you. Have another, actually, this is quite legal, actually, Kala. I think it's for you. If a party records the conversation without the other party's knowledge, can this recording be admissible in court or tribunal, especially in an employment dispute?
So in Singapore, there's no laws that prohibit you against secret recording. So you can go ahead and record. As to whether that's going to have credibility as a piece of evidence in court, without more, the answer is yes. But of course, that evidence can be potentially attacked as well. So short answer, yes.
Thank you. And we have, maybe we'll just take one more. For the progressive wage model for administrators, I think more for Patrick, if the staff is paid much higher than the guideline salary, they're asking, do they need to send them for training by September 2024 to comply?
Yeah. So I would like to use this opportunity to speak a bit more about progressive wage model. The progressive wage model actually involves four ladders. Firstly, the wage ladder, which Kala alluded to. We don't call it minimum wage, but they're actually wages for different rungs of the ladder as you move up. Junior, senior, chief, in even executive level. So that's the wage ladder. But there's also why we call it progressive wage model, because there's also a career ladder. So as you move up, you don't, for example, if you are a retail assistant, you don't end your whole career after 30 years as a retail assistant. We want you to move up. Senior retail assistant, maybe a retail manager, and even division head, and really move up the career ladder. But the other two important ones are actually, firstly, the skills ladder. So therefore, there's actually packed with the particular level of salaries. We won't just want to really increase salaries or put a base salary for the sake of putting a base salary. That's like any other country in the world is doing through the minimum wage. What we hope is to move in tandem. Wage goes up, you have better prospects in terms of career. At the same time, also you must have better skills. So that's why there's a training and skills requirement and certification requirement, so that we don't blindly just increase wages, but we justify it through better career prospects for the employee, better skills, and finally the fourth ladder is better productivity. So with better skills, if you are able to perhaps even use, instead of doing prowling, use CCTVs, for example, or use technology, tablets, etc., to make your work safer, smarter, faster, and therefore increase your productivity and contribute to your company. So that's how in Singapore we roll out the progressive wage model. Progressively, the wage goes up, but not just the wage, the career, the skills, and the productivity.
Thank you very much. Wow, we've talked so much. So we're going to wrap up. But before we do that, I'm going to get Kala. Can I get you to share one thing that you would like our audience to take away from today's webinar? That one thing.
Firstly, everything that I've said today are my personal views and does not reflect the views of my organization. I should have said that up front. But very importantly, what I said just now in relation to employment and family, we spend a lot of time at work. So you want to make it work both ways. Employers, you want to value your employees. Employees, you want to be enjoying coming into work. It's at the end of the day, finding that balance between everyone. So be it in relation to discrimination issues, be it in relation to harassment issues, be it in relation to wage and so on and so forth. Employers, you do need to make sure that there are proper policies put in place so that it acts as a guidance for all of your employees as well. And then make sure there's adequate awareness created for that, and training on the policies, but also a constant sort of regular training for everyone to sort of upskill themselves as well. I guess that's the key thing I want to emphasize, because everything else is law and it will keep changing. It will keep getting more difficult, I think, for compliance. But if you have it the way I suggested, I think it will sort of not be so hard to comply with. So.
Patrick, how about you?
Well, I have the hard sell. If you're not a union member yet, be a union member. If your company is not unionized, unionize yourself. But more importantly, thanks to this LawWorks partnership between Pro Bono SG and NTUC, the labor movement, we have in the past decade done what I call the 3-piece meal. So besides this evening's primer, we also have a pocket series and some new developments will be coming up next year in new areas which will better look after our workers. And finally, the third piece of the 3-piece meal is our monthly legal clinics. So if you want to get a short consult, do sign up for our monthly free legal clinics, which we do for union members. So that's for it.
Thank you. My takeaway from both of you, I think, is for employers to start having these conversations. I mean, 2024 is not that far. The runway is going to be very, very short. And having these conversations with the employees, and employees should be a union member if they can, and also reading up what are their rights and the laws. And I think I have the 22 recommendations right in front of me, and they're very interesting. And I recommend everyone to actually read it because it's very good, I must say. So I hope all our audience found the webinar today very, very useful. Now, if you're facing any issues, or if you're an NTUC member and you're keen to register for a legal clinic session, you may write to LawWorks at ntuc.org.sg. If you're not an NTUC member, do consider registering, or you can approach Pro Bono SG at help@probono.sg. At the end of this webinar, a survey form will pop up on your screen for your completion. We really appreciate your feedback and comments. And because of your feedback and comments, we can do such great webinars like this and having Patrick and Kala here. And we will also take in your feedback to improve our webinars in the future. Now, with that, on behalf of Pro Bono, SG, and NTUC, thank you, Patrick and Kala.
Thank you.
And thank you, everyone, for joining us today. Have a great week ahead.